Now, touching very quickly on a response to notice of arbitration, pursuant to Article 4 of the UNCITRAL rules, within 30 days from the receipt of the notice of arbitration, the respondent shall submit a response to the notice of arbitration. Essentially, the response should include the name and contact details of the respondent and a response to the part in the notice of arbitration, which deals with arbitration agreement, the contract, the brief nature of the claim, as well as the remedy sought. Now, you may also include in your response to the notice of arbitration any plea as to jurisdiction or lack of jurisdiction, or any counterclaim that the respondent wishes to seek as far as the set-offs are concerned.
Basically, anytime you have money crossing a border, you're going to want arbitration. And if you look at the statistics on the slide here, this is from a 2018 International Arbitration Survey that was conducted by PwC and Queen Mary, University of London. You'll see that of the respondents, 49% said that their preferred method of resolving cross-border disputes is international arbitration, combined with other forms of ADR, usually mediation in this case. So you would have perhaps a staged situation where you first go to mediation, and if you can't resolve the dispute through mediation, then you go to international arbitration. Another 48% of the respondents said they would prefer to go directly to international arbitration. So you can see there that we've really got 96% of the respondents saying their preferred mechanism for resolving cross-border disputes is arbitration in some form.
The limitations to party autonomy. I'm starting with the English position, and I mentioned earlier that I will come on to the English position. The English position actually represents a good example of how there are limitations to party autonomy and what they are. So the first thing you see in the general principles in Part 1 of the English Arbitration Act of 1996, and you'll see that the arbitration legislation of England goes back a long way, but in fact hasn't been modified in that long, and actually still does a very good job by way of a frame of reference of what is a good legislation. So what does Principle B say? It says, and I'm reading from the slide, the parties should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in the public interest. So there you go, there's a limitation to party autonomy.